Mr. Thomas. Good afternoon.
You can hear me okay?
I can indeed.
Very well. Sir, the police are the public, and the public are the police being the only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the interest of community welfare and existence. Sir Robert Peel's 7th principle of policing. However, as the evidence in this inquiry shows, the SDS forgot they were citizens in uniform and instead treated fellow citizens as enemies. This inquiry was convened because our democracy recoils at the notion that those who challenge the state can be spied upon. So John, the statements you will hear today are not simply historical records, they are the lived experience of citizens who sought justice and found themselves under surveillance for doing so. Behind each intelligence file is a mother bereaved, a brother grieving, a son traumatized, people whose lawful campaigns were treated as threats. These opening remarks gather those voices and lay before you the pattern of fabrication, intergenerational targeting, trauma, and mission creep we say the evidence plainly shows. You see, people were placed under covert scrutiny, not for any threat they posed, but for daring to hold the Metropolitan Police to account. So, these are the opening statements of 6 clients represented by Bat Murphy solicitors, Myrna Simpson, Bernard Renwick, Lee Lawrence, Winston Silcott, Sir Dr. Graham Smith, and Mark Metcalf. My name's Leslie Thomas of King's Counsel, and I'm leading Sam Jacobs. Myrna Simpson, the mother of Joy Gardner, Bernard Renwick, the brother of Roger Sylvester, Lee Lawrence, the son of Cherry Gross, were each the subject of reporting in connection with campaigns for justice for the death of a family member killed in contact with the police. Winston Silcott was the subject of reporting as the victim of a miscarriage of justice after he was falsely convicted and subsequently acquitted of the murder of P.C. Blakelock. Dr. Graham Smith founded the Hackney Community Defence Association, the HCDA. Mark Metcalf was centrally involved in the Colin Roach Centre. Each was the subject of wholly unjustified undercover reporting in the context of pursuing entirely lawful and peaceful means of seeking accountability. 4 of those whose behalf statements are made, and Stafford Scott, who has provided the statement, are black. None have been accused of criminality or breaches of public order in the furtherance of their campaign. All were involved in legal proceedings involving the Metropolitan Police. These are not features unique to our client group. They are shared by a number of non-state court participants across this inquiry. We set out a number of introductory themes before turning to the individual opening statements. From their stories, recurring patterns emerge. These themes are not academic abstractions. They are the fingerprints of a policing unit that has lost sight of its purpose. First, a feature arising across numerous reports in relation to justice campaigns is fabrication and falsehood. Reports made on the, quote, Friends of Roger Sylvester, a group that never existed. The HCDA was falsely described as an anarchist front. Trevor Morris claims to have dramatically intervened in a meeting regarding the death of Joy Gardner and, quote, stopped a riot. Yet the meetings were focused on peaceful campaigning. Myrna Simpson's campaign was falsely reported to be run by a member of the SWP. Stafford Scott is falsely accused of threatening civil unrest. The Colin Roach Centre was falsely reported to have been planned to attack a unionist politician. Dr. Graham Smith was falsely reported to have received the gift of a motorbike from a client who had successfully sued the commissioner. HN15 Mark Jennings' falsehood, including reporting on matters for which he was the agitator, and the isolated incidents of violence which can be recalled by Mark Metcalf, were those precipitated by Jenner himself. This reporting may have some element of bias and prejudice that anyone politically to the left and or black people may be properly considered dangerous or at least hopelessly open to exploitation. Indeed, as HN43 Peter Francis describes, HN86's view of black justice campaigns were that they were unable to think for themselves and therefore they must all be led by some more radical left-wing groups to advance their own agendas. However, there was also deliberate exaggeration. It's difficult to align open an explanation for it other than deliberate exaggeration as a pretext for ongoing surveillance and justifying the ongoing work of the SDS. It was described in the SDS closing report as, I quote, padding out an otherwise redundant operational deployment. This was a unit whose activities had become wholly divorced from any possible legitimate purpose, and its continued existence was served by fabricating prospects of subversion and disorder where there was none. Let me turn to the second theme: intergenerational surveillance and legacy targeting. In earlier tranches of the inquiry, it has seen the reporting on Celia Stubbs over a period of decades. Decades after Blair Peach's death, she was still reported on. In this tranche, the evidence before the inquiry includes the reporting following the shooting of Cherry Gross in 1985, witnessed by Lee Lawrence as a young boy, to Lee Lawrence's prosecution in 2000, surveillance that spanned 15 years across 2 generations. Winston Silcott's campaign was monitored and reported on long after his acquittal. We see children who have suffered the terrible trauma at the hands of the Metropolitan Police have that trauma compounded by the targeting of covert intelligence gathering years later. Joy Gardner's son was 5 years of age when he witnessed her suffocation, and Lee Lawrence was 11 when he witnessed his mother being shot. It reveals a pattern. Once targeted, always targeted. Families were treated as suspect categories across decades, embedding institutional mistrust and compounding trauma. Let me turn to the third theme: trauma and secondary victimization. The family justice campaigns not only have in common that they were each seeking justice, they also have in common that they were spied on in their grief. The spying even extended to UCOs attending memorial services and reporting on funeral services. This pattern was familiar to the SDS, with UCOs attending the funeral of Blair Peach. SDS intrusion towards families in grief and who were the victims of injustice risked re-traumatizing families already suffering from state-inflicted harm, and in the event has done so. This theme is distinct from racism or other lack of public order justification, for it shows a disregard to the sanctity of mourning and private life. It raises the ethical question: Sir John, what kind of police force spies on grieving families? The fourth theme: the blurring of police functions and abandoning even a pretense of policing public disorder. The SDS repeatedly strayed into reporting that it could not even claim to be related to public order, notably reporting on civil claims and defence strategies and the monitoring of members of parliament and elected officials. Even a pretense of policing public disorder was abandoned. This mission creep reveals covert powers being deployed to protect the institution of the Metropolitan Police from accountability. It leaves those reported on considering just how corrupt the SDS really became. Many core participants describe a phenomenon of curious burglaries or entries into their homes, which appear more consistent with the taking of information than the taking of property. This concern features in the evidence of the HCDA, Bernard Renwick, and Winston Silcott. It's a concern raised by other core participants in their witness evidence. The question arises as to whether the SDS had any role to play in this behaviour. Fifthly, complicity of managers and the lack of oversight. It's an obvious cause for concern that the problem was known to and sanctioned and approved by managers who signed reports and failed to filter and disapprove of racist language or privileged material. They acted in plain defiance of Home Office guidance and indeed any basic sense of a proper functioning of the police. The rot ran up the chain of command. 6. The constitutional significance of spying on justice campaigns. Some of the subjects of reporting were litigants in civil proceedings or supported those litigants. Indeed, they appeared to have been the target of reporting precisely because of their involvement in litigation involving the police. And it appears the interests of the Metropolitan Police Service in resisting it. In so doing, the SDS surveillance interfered with access to justice, a constitutional right. Surveillance of legal processes themselves undermines the rule of law by tipping the scales in litigation. 7th, chilling effect on the democratic participation. The pernicious effect of surveillance of accountability groups and justice campaigns was and is the suppression of lawful democratic engagement. That was recognised a decade earlier in the 1984 Home Office response to the Special Branch report on police accountability groups, in which the MPS was directed that it should not be investigating groups or individuals, quote, because they are highly critical of the police. But we see in this tranche that it continued determinedly and prolifically a decade or more later. Citizens have learned that campaigning against the police misconduct risked infiltration and monitoring. 8th, smearing in the media. It's a common experience of families bereaved by deaths following police conduct that in the aftermath, they and or their loved ones are demonised in the press. Winston Silcott was branded as violent and demonised at the time of his trial. Roger Sylvester's descriptions of him being violent and strong and a drug addict. Joy Gardner was similarly characterised as violent and dangerous. That well-known trope, the big, black, dangerous person sharing the colour of my skin makes me extra dangerous. You see, there's a suspicion that this common experience is fueled by MSP briefings. The obvious concern is that this partly explains the SDS's avid interest. Any information on these campaigns was good information because it might be that it could be used by the MPS in seeking to diminish campaigns for accountability. Sir, the inquiry must consider whether the SDS's intelligence directly or indirectly fueled media disinformation campaigns, amplifying stigma and harming families. 9th, missing reports and missing witnesses. Both Trevor Morris and Mark Jenner have stated that they cannot remember much of the detail of the events being considered, and that they submitted many more reports that have been disclosed. UCOs and the SDS documents serve as substantially incomplete sources to understanding why groups are targeted, the extent of UCO reporting, and, crucially, what was done with the intelligence gathered. The refusal of HN81 Dave Hagan to give oral evidence has left these witnesses deeply frustrated. The truthfulness of his justification for reporting on family justice campaigns is strongly contested. His refusal to give oral evidence contrasts with the open and forthright evidence engagement by those who were spied upon. I now turn to my opening statements. Opening statement of Myrna Simpson. Myrna Simpson is the mother of Joy Gardner. Joy travelled to the United Kingdom to join her mother and the rest of her family in 1987. She had a brief and unsuccessful marriage to a British citizen, and the Home Office sought to deport her. Can we put up image MS2, please? Is the image up?
Yes, it is.
Thank you. You can take it down now. Thank you. Myrna describes Joy as a warm, caring person and mother of 2 children. She was studying at university to try to fulfill her dream of becoming a journalist. She was an active member of her local church, which she regularly attended with her young son. So on the morning of the 28th of July 1993, Joy was at home in Crouch End with her then 5-year-old son. Joy's home was raided by Metropolitan Police officers, the so-called Aliens Deportation Group. They had orders to detain and deport Joy and her son. A police officer unplugged her phone to prevent her from calling her solicitor. Joy was then forced face down on the floor with her hands were then bound to her side with a leather belt, to which she was handcuffed. Her legs were strapped together. An officer then wound elastic adhesive bandage around her head several times. A second bandage was wound around her head in the opposite direction. She was then gagged with a total of 13 feet of surgical tape. Her son saw some of this restraint and heard all of it. Joy was then taken to hospital in a coma caused by lack of oxygen. She died from asphyxiation caused by that restraint. In 1995, 3 officers of the Alien Deportation Group stood trial on charges of manslaughter. They were acquitted. There has never been an inquest or public inquiry into Joy's death. Myrna Simpson has always sought to honour her daughter by campaigning for the truth and for accountability. Her struggle has not ended that. That is the context for the campaigning work carried out by Myrna Simpson through the Justice for Joy campaign. Can we put up image MS1, please? Thank you. You can take that down. Joy's death was a key priority at the very highest levels of the Metropolitan Police. Baron Condon, the commissioner at the time, described to Mark Ellison his shock at the involvement of the Aliens Deportation Group. He described pressing the Home Office for an independent inquiry after the police officers were acquitted, and his concern that the incident might precipitate riots. Reports were filed upon Myrna Simpson by at least 4 SDS officers. We see the theme of fabrication. HN78 Trevor Morris claimed that the campaign was being run by a prominent member of the Socialist Workers' Party. Myrna Simpson refutes that entirely. The individual attended meetings but did not influence the campaign, and indeed, Myrna would not even have said that he was part of it. Trevor Morris also claims to have spoken at a campaign meeting in Tottenham Town Hall, and in so doing that, he stopped a riot. Myrna Simpson has no memory whatsoever of that event, and she doubts it's true. She does not wish to give it the dignity of a response. You may find it striking that at no point does Trevor Morris, nor any of his managers who commended his work, appear to have considered the ethics of a serving police officer using his covert identity to speak at a public meeting about the death of a person at the hands of the police, the very same police force that this officer is a member of. We also see the theme of smearing. The claim by HN43 Peter Francis that SDS officers were specifically tasked to smear the Lawrence family and Joy Gardner resonates with Myrna Simpson's experience in relation to the events following Joy's death. Myrna describes her shock and disbelief at hearing officers claim that when they were on trial. She has provided to the inquiry an academic article outlining the derogatory and untrue reporting in the media on her daughter. She harbours a concern that at least part of the motivation for targeting the campaign was to seek an opportunity to undermine it, if necessary, by smearing Joy's character. Myrna Simpson explains that the campaign was a group of family and friends who came together to seek justice. Myrna spoke about her daughter's to educate the public. She sought support from local members of parliament. She publicised everything. She deplored violence. Despite the fanciful speculation of riots and disorder, her campaigning was peaceful and sought to bring the local community together. Newspaper reports of the time report that Myrna Simpson and Bernie Grant MP calling for calm. Her campaigning was never influenced or manipulated by political organisations, and yet every speech she made, every plan she made, and every event she attended to was reported on by SDS officers and filed by Special Branch. It had no justification. We'll leave the last word of this statement to Myrna Simpson. Quote, "Our aim was not to make trouble. It was just to get a voice as we needed justice for Joy, for the way she was killed. We still need that justice." Bernard Renwick's opening statement. Bernard is the brother of Roger Sylvester. His participation in the inquiry has been on behalf of his family, and in particular his parents, Sheila and Rupert. Sheila and Rupert were born in Grenada and came to this country in the early 60s, living in North London. Sheila worked in the maternity unit at the Whittington Hospital until she retired, and Rupert was a carpenter for Islington Council before becoming a black cab driver. They had 5 children. Can we put up BR number 1, please? BR1. That's a picture of Roger. Thank you. You can take that down. Roger was born at the Whittington Hospital in 1968. After finishing school, he commenced the course at North London College, but had to leave after he suffered a serious assault in 1986. Roger began to experience mental health difficulties after that assault. With the support of his family and friends, he continued to work, and for a short while, he was a computer operator for the Metropolitan Police. Tragically, Roger Sylvester was declared dead on the 18th of January 1989. He died as a result of the prolonged restraint by 8 police officers 1 week earlier at St Anne's Hospital in Tottenham. At the inquest into his death in 2003, a jury returned a verdict of unlawful killing. The Inquisition describes the jury's findings, including that more force was applied than reasonably necessary. That verdict was later quashed by the High Court. Bernard Renwick's family issued a statement expressing their distress at the judgment. In June 2005, the CPS decided not to prosecute the officers, a decision that the family felt had denied another jury the opportunity to consider the facts for themselves. Bernard describes in his statement that the fact that the death came at the hands of the police made it even more traumatic and difficult to digest. His statement goes on to describe how the family's trauma was made worse by police officers seeking to cast Roger in a bad light. Press reports quoted members of the Police Federation and Metropolitan Police describing Roger as violent, strong, drug addicted. This was the background to the family's decision to start the Roger Sylvester Justice Campaign, initiated by two of his cousins. The first meeting was a meeting for the family held at the home of a cousin. It was always a family campaign led by the family and not by political activists. While the campaign has never ended, its period of intense activity was between 1999 and 2005, while various legal proceedings were taking place. Bernard Renwick describes regular meetings, usually at the home of a family member, sometimes as often as 3 times a week. Events such as memorials, vigils, and demonstrations were held. The first event, at the end of January 1999, was a march from Roger's home to Tottenham Police Station, where a vigil was held. All of the events were publicised as widely as possible through websites, leaflets, emails, and word of mouth. Sir, the first SDS report concerning Roger, the Roger Sylvester campaign, was made on the 25th of January 1999, the day after the vigil. It was prepared by HN81 Dave Hagan. Bernard Renwick recalls the march well. He disputes Hagan's assessment that the march was predominantly made up of black youth. He describes 250 people being a mix of all ages, with the march being led by his parents and their pastor. He's been able to produce a picture of his parents at the march. Can we pull that up, please? That's BR2, please. Thank you. You can take that down. A further report was filed the following week. In the report, Dave Hagan has started to refer to the friends of Roger Sylvester. He describes complicated machinations between Movement for Justice, the monitoring group, the New Monitoring Project. He described Myrna Simpson, the mother of Joy Gardner, having contacted the friends of Roger Sylvester. Bernard does not recognise the events described in that report. He has never heard of the friends of Roger Sylvester. He is clear that the family never worked with MFJ. He refutes the idea that Myrna Simpson acted as a conduit between his family and the MFJ. She was another bereaved mother with shared experiences. The reports give a fantastical and wholly inaccurate account of supposed alliances and political infighting. It was a campaign for justice run by family members and devoid of any political interference. The inquiry has been addressed on the issue of racism both at an institutional level and on the part of individual officers. Sir, I urge you to listen to the voices of those affected to understand the pervasiveness of this culture and the impact on those affected by it. Bernard describes the racism inherent in the police response to his brother, as he puts it, and I quote, "Rather than recognising he was a vulnerable young man showing signs of mental illness who needed their help, they saw him as a black man who posed a danger." He recognises that same response in the intelligence reports and policing of the campaign. This runs through the concoction by Dave Hagan of political manoeuvring between bereaved families and through his misdescription of the nature of the campaign and those who supported it. It resulted in Wright Police attending Roger Sylvester's inquest to be met by family holding hands in a prayer circle. So it was, you could just imagine just how dehumanizing and distressing that was. That response by the police to a grieving family at his inquest. I turn to the opening statement of Lee Lawrence. Lee Lawrence is an award-winning author. His book, The Louder I Will Sing, A Story of Racism, Rights and Redemption, was awarded the Costa Prize in 2020. He's the chief executive of the Cherry Gross Foundation, which he founded to honour his mother. The foundation aims to tackle youth violence through a range of disciplines, from education and training to improving institutional practices to adapting storytelling resources through restorative justice. On the 12th of October 1999, Lee witnessed a racist attack. As he was driving home, he saw a young Somali boy being chased and attacked by a gang of white youths. He stopped his car, called the boy over. He was told that the assailants were racist. Lee gave the assailants a warning to leave the young person alone. They were verbally abusive to Lee as he left. Following that incident, Lee was asked to attend an interview at the police station where he was charged by the Metropolitan Police with assault. The assailants fabricated an allegation against Lee, and the police chose to act on their account. This was the first consequence for Lee of intervening to prevent a racist attack. The second consequence was that an undercover police officer, HN81 Dave Hagan, began reporting on his case. The reports disclosed to Lee in the beginning of March 2000. Let me read that again. The reports disclosed to Lee begin in March 2000. The first SDS report on him wrongly asserts that Lee had approached the Movement for Justice for support and states that there was an attempt to turn his case into a race issue. The report includes details of Lee's solicitors and the actions being taken to secure evidence relevant to the defence. A telling lie in the report is a reference to Lee as Lee Gross, the son of Cherry Gross. The Gross family were a target. More than a decade earlier, Cherry Gross had been shot in her own home by police officers, and the SDS had shown an interest in her case over many years. Can we put up image LL1, please? Here's a picture of Cherry. Thank you. We can take that down. Thank you very much. On the 28th of September 1985, Lee, aged 11, along with his sister, was asleep in his parents' bedroom. He was woken by a loud noise. He saw his mother get out of bed to investigate, at which point she was shot by a police officer. Lee was hysterical with fear, but told to shut up by the officer. Can we put up image LL3, please? Thank you, you can take that down. The police permitted a press photographer to enter the house and photograph Lee and his sisters in their distress while traumatized by these events. Lee describes a childhood shaped by these events, and he and his siblings became the main carers for his mother, who, having suffered paralysis below the waist as a result of the shooting, was confined to a wheelchair. Lee did not feel able to leave home until he was 27 due to his caring responsibilities. He continued to see his mother every day until her death in 2011. Can we put up image LL2, please? Thank you, we can take that down. After his mother's death, Lee channeled his pain into setting up a charity in her memories, followed by a mobility taxi firm. He fought for an inquest into her death, and this was eventually granted. The inquest took place in 2014. This was the first occasion that Lee and his sisters were able to see the full evidence of the events on that night in September 1985. The inquest jury criticised numerous failures in the planning and conduct of the police raid. Sir Bernard Hogan Howe, commissioner at the time, issued an unreserved apology. While this was meaningful for Lee and his family, it was an apology that his mother never received. The first SDS report that referred to Cherry Gross was filed less than 6 weeks after she had been shot. The SDS annual report in 1985 contains a list of groups that were effectively penetrated by the SDS officers in the previous year. This list includes the Gross Family Support Campaign. Chair, you will recall the evidence of HN 115 Tony Waite that penetrated means an officer was in an organisation and that one visit was not enough. There had to be repeat reporting or attendance. All of this has come as a surprise to Lee Lawrence. He was a child at the time, but does not remember a definable campaign. He simply recalls that some close family members and friends organising meetings in the local community for a short period of time. It is this history that provides the context to a report by the SDS officer in 2000, some 15 years after Cherry Gross had been shot, dealing with the prosecution of Lee. The inquiry has disclosed a total of 10 further reports filed by Hagan on Lee's trial and acquittal. Of note is, firstly, in two of the reports, Lee Lawrence is portrayed as the perpetrator, as alleged by the white youth. It's unclear why Hagan has repeated these false allegations and from where he obtained them. Secondly, two of the reports accuse Lee and the MFJ of seeking to turn the case into a racial incident. As Lee states, this is an absurd comment as it was a racial incident from the outset. He had intervened to stop a racist assault and had himself been charged with racially aggravated assault. Thirdly, a number of reports contain information concerning the legal process. The initial report gives details of solicitors who were acted for him. Two reports refer to details of the defence case following the acquittal. Two reports are concerned with the possibility of civil action against the Metropolitan Police. Lee Lawrence has dealt with the most unimaginable trauma and has put his experience to constructive use, both for himself and the wider community. The contrast between his commitment to using law to achieve accountability and the nefarious actions of the SDS officers could not be starker. Lee's second book, The Colour of Injustice, has just been published. In this book, Lee explores the impact of his mother's shooting on him and the family's campaign against a broader backdrop of racism in the criminal justice system stretching back to the 18th century. On the 30th of September of this year, The Guardian published an interview with Lee. On being asked about Lee's work with the Metropolitan Police and the theme of how rare it is for the police to be held accountable, he is quoted as saying, "We speak about culture a lot within the Met, and if the officers are doing wrong and not being penalised for it, and some are actually being promoted for it, what type of culture is that fostering? That it's okay to do the job with no integrity? What I've realised, being on the opposite side, is that there's a damage limitation perspective from the Met as an organisation. Sir, we ask you to consider whether that damage limitation perspective was a driving factor, if not the only factor, in such persistent interest in campaigns for justice and police accountability." I now turn to the opening statement of Winston Silcott. In October 1985, PC Keith Blakelock was killed during disturbances on the Broadwater Farm estate in Tottenham. The disturbances occurred after a local woman, Cynthia Jarrett, died from a heart attack after 4 police officers entered her home. In March 1987, Winston, along with Mark Braithwaite and Engin Raghip, were convicted of the murder. He was sentenced to life imprisonment. In fact, Winston and his co-defendants were all innocent. Winston's conviction was based solely on fabricated confession recorded in Detective Chief Superintendent Melvin. The convictions for all 3 men were eventually quashed by the Court of Appeal on the 5th of December 1991. He was represented by another court participant in this inquiry, Michael Mansfield of King's Counsel. The Court of Appeal stated in its judgment that, and I quote, The text of this interview represents the totality of the evidence against Silcott on the charges of murder and riot. He did not appear in any of the thousands or so photographs taken at the scene on the night of the riot. Neither was there any scientific evidence relating to clothing, footwear, or blood staining. Nobody gave evidence against him. End of quote. Evidence presented to the Court of Appeal established that the unsigned statement containing the confession was falsified. Not only had it been taken in the absence of Winston's solicitor, deliberately concocted pages were inserted into it. In giving judgment, Lord Justice Farquharson stated, "What is the effect of that evidence? It clearly destroys the basis of the Crown's case." During the time they were wrongly convicted, the families and friends of the three men worked tirelessly to uncover this miscarriage of justice. They were frequently referred to as the Tottenham Three. Their campaigning was supported by a very broad spectrum of society, from members of the public to politicians and trade unions. The local community took a particular interest in, and work of the Broadwater Farm Defence Committee was addressed through the evidence of Stafford Scott in Tranche 2 of this inquiry. Winston's brother, George Silcott, was Winston's main source of support. He lobbied on Winston's behalf, spoke at public meetings, and even ran for elected office in his efforts to fight this injustice. He was often aided by a friend of Winston called Delroy Lindo. Winston was not released until after, Winston was not released after his successful appeal. While awaiting trial, Winston had been convicted of a separate murder. Winston has always maintained that he acted in self-defense in that case. He explains his concerns that the trial was adversely affected by the Metropolitan Police officers who put in place exceptional security measures, attending all hearings, and even cheered in court on his conviction. The consequences of his second conviction meant that Winston remained in prison until October 2003. His brother George continued to campaign on his behalf, and the campaign became known as the Winston Silcott Defence Campaign. After his release, a BBC News quoted the Vice Chair of the National Assembly Against Racism saying, quote, "Just as he is being released, the media are showing a picture of Winston that makes him appear as someone who should be feared. This is an image that has been built up over the years, and I think there is a belief amongst police officers that he is guilty of the Blakelock killing, even though he was cleared in a court of law." There are three striking facts that emerge from the SDS reports. The first is, none of the key people who played a role in the campaigns were involved in any left-wing politics, and yet they were the subject of reporting by SDS. Reports filed upon George Silcott, Delroy Lindo, and Stafford Scott with alarming regularity. Second, there was never a single public order concern associated with their campaigning. Third, the reporting on the campaign continued long after Winston's conviction for the murder of PC Blakelock was quashed. The reports filed on Winston commenced shortly after his arrest, and they continued until at least 2001, more than a decade after the quashing of his conviction. Reports on him, his brother, and the campaign were filed by at least 6 different undercover officers. At one point, HN5 John Dines moved into Helen Steele's home. Her garden backed onto the Silcott family home. There followed a number of unexplained incidents at the family home where items were moved or disturbed. The reports go beyond detailed support offered to the campaigning by political groups. They touch upon the appeal hearings in Silcott's case and the trial of Detective Chief Superintendent Mervyn, the officer who was prosecuted and acquitted for falsifying the evidence against him. They include personal information about his brother George Silcott. When George Silcott stood for election to his local council, this was the subject of an intelligence report. Details of Winston's contact with his friend Delroy Lindo are reported on by Dave Hagan, including the content of telephone conversations made by Winston from prison. It is even stated by HN81 Dave Hagan in his Hearn interview that he provided information for the police to defend the Lindo civil proceedings against the commissioner, but his information could not be used. It is telling that a UCO reported intelligence, apparently knowing that the purpose of the reporting it was in resisting civil proceedings. There is clearly and was clearly no justification for this reporting, but Winston Silcott would like to understand its purpose and its motivation. HN 43 Peter Francis's evidence on the issue requires close scrutiny. On the one hand, he states that his reporting on the campaign came about because George Silcott approached the YRE for help. He describes this as reporting on a group without infiltrating it. However, he also claims that he was specifically tasked at various points to report on single-issue campaigns, including the Winston Silcott Defence Campaign and the Broadwater Farm Defence Committee. Moreover, it should be noted that the reporting on George Silcott did not start when he was in contact with the YRE. This reporting had already been going on for a decade. The more compelling explanation may be that the SDS' long-standing interest in the ability to infiltrate justice campaigns, particularly black justice campaigns. When assessing the motivation for reporting upon Winston's, so you may wish to have in mind a statement issued by the Metropolitan Police in December 1999, after the Commissioner settled the civil claim arising from the overturned conviction. The statement indicated a continued antipathy towards Winston Silcott and also an institutional reluctance to accept the clear and unambiguous findings of the Court of Appeal. It said, and I quote, "In settling this action for £50,000, we have not admitted liability. We recognise that this decision will cause disappointment and distress to many officers in the Metropolitan Police Service, especially those on duty on the night, most of all to Keith Blakelock's widow Elizabeth." Close quote. In his witness statement, Winston describes how disturbed and vulnerable he feels as a direct consequence of the reporting on him and his family. His concern has always been that he will be vilified and targeted by the police for a crime he did not commit. He describes that feeling that the police have a target on his back and states that they sought to create their own false impression of his campaign so that any action they took against him would be justified. As he puts it, and I quote, "There was no justification for them being there and writing reports at all. If you have someone under surveillance and they've not been doing the things that you're worried about, why not just leave them alone?" But they continued and continued and continued even after my conviction was quashed. I now turn to the opening statement of Dr. Graham Smith. Dr. Graham Smith is a recently retired lecturer, having taught for many years at the University of Manchester, where he specialised in police, counter-terrorism and human rights law. He has particular expertise in the mechanism of police complaints and has been a consultant on combating impunity for human rights violations for the Council of Europe. Dr. Smith was the principal founder of the HCDA and served as secretary for much of the 7 years it was active between 1988 and 1995. In investigating and publicising allegations of police violence and misconduct, HCDA was active at a time when significant developments in international human rights law required state authorities to effectively investigate the alleged human rights violations and remedy impunity. It is in the context of those developing obligations to investigate and remedy impunity that the SDS and Special Branch were targeting and reporting on the HCDA and Dr. Smith, an organisation and an individual known to be actively combating impunity for human rights violations. Dr. Smith and the public at large have a right to know why. The earliest available SDS report on HCDA is dated the 23rd of August 1988, only 1 month after its launch. Attributed to HN10 Bob Lambert, it falsely characterises the HCDA as a front organisation for local anarchist activists. It was nothing of the sort. HCDA was formed at a conference organised by the Trevor Monaville campaign and the Hackney Anti-Fascist Action. From its inception, HCDA was a self-help group of victims of police injustice which, given up on the police complaint system, turned to the civil courts. SDS documents expressly stated that HN78 Trevor Morris and HN50 Mark Jenner targeted HCDA. In February 1995, Mark Jenner was tasked with targeting HCDA, which was, quote, involved in the coordination and opposition to local police allegations of harassment, racism, and wrongful arrest. Clearly, opposition to harassment and racism of the local police force was the basis for targeting. Special Branch's interest in the HCDA was likely to increase by its growing reputation and profile in supporting victims of police injustice in criminal and civil courts and campaigning for for police accountability. Much publicity surrounded arrests of an elderly couple in January 1989, and assault of a motorcyclist in July of the same year. These cases attracted national and regional and local media interest. By 1992, broadcast and media coverage accompanied HCDA's investigation conducted in parallel with the Metropolitan Police counter-corruption investigation into Stoke Newington police officers, codenamed Operation Jackpot. A Channel 4 TV cutting-edge documentary was aired titled Coppers on policing in Hackney. That Channel 4 programme highlighted HCDA's civil action strategy and its effectiveness, reporting that, quote, publicly, senior officers dismiss HCDA as a politically motivated fringe group, but it is clear that HCDA's strategy of public accusation and civil litigation has put the police on the defensive. Many of the cases taken up by HCDA involve allegations of police brutality and racism. A common pattern was victims of police violence being falsely accused and charged with offences of assaulting police officers in the course of their duty. Following acquittal, and successful defendants would then turn to the civil courts to gain redress. Between January 1989 and September 1991, HCDA took up 130 cases, 57 involving allegations of assault by the police, and 26 civil actions, 22 involving claims of assault. For the next 3 years or so, HCDA prioritised drug cases as it struggled to cope with the number of people alleging planting by Stoke Newington drug squad. Within 9 months of Operation Jackpot's announcement in January 1992, acknowledged by the MPS as the worst case of corruption in a decade, HCDA had examined 40 Stoke Newington drug cases, 36 involved black people, 20 Jamaican or of Jamaican descent, and civil proceedings had been commenced in 9 of the cases. In total, 14 convictions in respect of drug offences were eventually quashed. HCDA took up 90 Stoke Newington Operation Jackpot cases, with 25 claims proceeding against the Commissioner. This is the context for Trevor Morris's evidence to the inquiry that he obtained access to HCDA's files and submitted several reports to the SDS, as did Mark Jenner. The only credible explanation for this reporting is that it was perceived to serve an interest in having knowledge of or being able to resist lawful campaigns for accountability, including civil proceedings. The reporting extended to Dr. Smith personally. Mark Jennings submitted 15 reports on Dr. Smith. Jennings' deployment in the field coincided with the disbanding of HCDA and the withdrawal of Dr. Smith from community activities. Jenner acknowledges Dr. Smith's withdrawal from community activities in a report dated the 13th of June 1995. This report contains personal information about Dr. Smith, much of which is wrong. Despite noting this withdrawal, Jenner continues to submit further 10 reports on Dr. Smith, the last one being on the 19th of October 1998. As to why he would gather and report such information, Jenner claims that he would have been provided with information he gleaned about Smith's personal circumstances, because at the time he'd understood that all such information would be wanted by the SDS to keep the special branch file on Smith up to date. There is an absurdity in the explanation given for the reporting. There are no reports available during the period when Dr. Smith had a registry file number and was active, a prominent member of HCDA, and yet at the point he withdraws and is no longer active, he becomes the subject of multiple reports, at one point 4 in 1 month. Jenner will need to explain why he had the understanding that Special Branch wanted to keep the registry file up to date. Another subject of the reporting in the Defendant's Information Service, or DIS, was Dr. Smith and others, was in 1984. it was a database of police officers found to lack credibility and whose evidence was either not relied on by prosecutors or the courts. The information was shared with criminal defence and police litigation solicitors and was the subject of legal professional privilege. The MPS took exception to this. Dr. Smith was written to by the Office of Data Protection Registrar and was visited by a lawyer in 1995 and received objections from the MPS and the Association of the Chief Police Officers. As Jenna reported in October 1995, the DIS is a database. It's available for a fee to lawyers. It lists the details of police officers who've been reported or convicted of criminal or disciplinary offences or have been the subject of complaints. This is an important source of income for CRC. This was just a reporting service, the sole aim of which was to provide information on the actions of the MPS. Jenna filed these reports, notwithstanding the obvious breach of legal professional privilege. He did so against the background of the DIS having a concern at the highest level of the Metropolitan Police, leading to attempts by them to block the service. The reports filed on DIS cannot simply be dismissed as collateral reporting. Reporting on HCDA, Dr. Smith and the DIS were entirely unjustified and improper. It was contrary to the Home Office directives that targeting of police accountability and anti-racist groups was strictly off limit. I now turn to the final core participant I represent, that's Mark Metcalf. Mark has provided a witness statement on his own behalf and on behalf of the Colin Roach Centre. Mark had been involved with a political trade unions and community actions for his entire life. It appears that the special branch had opened a registry file on him in 1987. He had a number of SDS reports on him between 1986 and 1994. The targeting strategy for Mark was prepared in February 1995, and it states that he will target anarchist activists in Hackney. It goes on to mention that Mark personally as being part of HCDA. In his witness statement, Jenna describes his long-standing strategy was to get close to Mark Metcalf. He states that it would give him access to a wider range of groups. This explanation makes very little sense. Mark Metcalf has never been an anarchist. SDS wrongly reports to refer to CRC and HCD as being synonymous. This was simply not the case. CRC, the Colin Roach Centre, was initially open to provide a community hub for groups such as HCDA, the local gay and lesbian group, and the Hackney Trade Union Support Unit. In 1995, it began to operate a membership and involve itself in local community campaigns ranging from housing, trade union work, supporting refugees and asylum seekers, and anti-fascist activities. Mark Metcalf describes CRC as first and foremost a place for advice. Jenna's witness statement asserts that the MPS were not interested in the activities of CRC because of its work on the police misconduct, but because of its interest in planned demonstrations and public disorder. This, we say, is clearly spurious. Not only was there an absence of public disorder to be interested in the contemporaneous records, the contemporaneous records make clear that the real interest, reason for the interest was the SDS, and you'll see that in the SDS annual report, where Jenna describes having a unique access to a range of anti-police campaigns in London. It was precisely because of the work on police misconduct, mischaracterised as anti-police, that CRC was of interest. Jenna describes the CRC as a stepping stone for getting access to a range of groups such as Red Action and the Irish Republican sympathisers. However, he notes that being associated with Mark Metcalf hampered this strategy as Mark had a poor relationship with them. As early as January 1986, Jenna attended such meetings on his own due to his own poor relationships, and yet continued to file reports on every aspect of Mark's life, from his job applications to bank accounts. Jenna explains his reporting on the basis of all the information was to be hoovered up, and that Mark remained one of his main targets, albeit this was difficult to fathom. At the end of Jenna's deployment, he suddenly disappeared after he'd mistakenly disclosed his name to Alison. Mark remembers Alison's fears for Jenna's well-being after this sudden disappearance. Mark reached out to make sure that he was well, to offer support. This contrast with the contrast between this empathy and concerns and the actions of Jenna and the SDS couldn't be more stark. Finally, let me come to some concluding remarks, and I know I'm right at the end of my time, but so if you can just bear with me 3 minutes, that's all I ask.
Of course.
Sir John, in each of these stories, the same question arises. What kind of police force spies on grieving families and those seeking justice before the courts? The evidence that Weaver outlined shows fabrication, racism, intrusion into legal privilege, and a chilling disregard for the rule of law. Our clients simply ask recognition of the wrong done to them and for reassurance that no other family will suffer the same fate. To borrow from Myrna Simpson, who speaks for so many, our aim was not to make trouble. It was to get a voice because we needed justice. That is why we're here. Now, we acknowledge the Commissioner's apology and his acceptance that the deployments of HN15 and HN81 against them were not justified. But let us be clear. We should never have been here in the first place. Any decent observer knows that grieving families are not legitimate targets of covert policing. There was no disorder to quell. There was no hidden criminality to expose. The only people exercising their right to demand justice. This has to be said. And the fact that we have to say this at all is a stark reminder of how far the Metropolitan Police has lost sight of its obligations of those it was meant to serve. And yet, there remains a painful omission. And I'm sure, sir, that you've spotted this. At the end of Celia Stubbs' closing statement in Tranche 1, her counsel called upon the Commissioner to apologise to her directly. You, sir, you replied, and I quote, "I hope that your last remarks are reflected upon and responded to." However, sir, Celia Stubb has still not received any response from the Commissioner. Despite these calls, there's been no personal apologies to the families of Cherry Gross, Joy Gardner, Roger Sylvester, or any of the other bereaved relatives who were spied upon. A general apology that does not even name those directly affected can never be enough. Until those families receive a personal apology, the stain on the reputation of the Metropolitan Police will endure. Thank you.
Thank you very much. The point you made at the end of your submission is a forceful and valid one. I was delighted that you began by quoting Sir Robert Peel, who should be in our hearts.
Thank you, sir.
I hope I do not mispronounce the name of the next advocate. If I ask for Ifeanyi Odogwu to be put on the screen, please.
Good afternoon, sir.
Good afternoon, Mr. I do hope I pronounced your name correctly. If I didn't, I apologise.
You pronounced it correctly, so I'm grateful.
Thank you.
I'm happy to address you now. I believe I was going to be after Mr. Rajiv Menon on the running order, but I'm happy to address you now. So
I do apologise. I've misread the running order that I have been given, and you are absolutely right. It is Mr. Menon who comes next. Thank you for correcting me, and at least I've got one thing right, pronunciation of your name. Mr. Menon, apologies to you.
No problem. Good afternoon, sir. In 1993, Duwayne Brooks was 18 years old. He lived in Charlton, southeast London. He was at college training to be an electrical engineer. Stephen Lawrence was his close friend. On the morning of Thursday, the 22nd of April, 1993, Mr. Brooks could not have imagined that within 24 hours, his life would be turned upside down and changed forever. That evening, whilst he and Stephen Lawrence were waiting for a bus in Eltham, they were the victims of a vicious and unprovoked racist attack. Stephen Lawrence was murdered. Mr. Brooks was fortunate to survive the attack, but suffered post-traumatic stress disorder for the following decade. He is now aged 51. The trauma shapes his life even today. From the very outset, when officers arrived at the scene of the attack, Mr. Brooks was treated appallingly by the police. At the police station, the police was so hostile to Mr. Brooks' account of the racist abuse shouted by the attackers that he felt the police were playing Jedi mind tricks on him. Scared, alone, and vulnerable, Mr. Brooks had the courage to stick to the truth. It is his courage that enabled the racist nature of the attack to be exposed. It is chilling how Mr. Brooks' experience and his treatment by the police mirror the earlier experience of Nathan Adams and his treatment by the police. Both were black teenagers from Southeast London. Both were the surviving victims of murderous racist attacks. Both were eyewitnesses. Both were harassed and failed by police officers who sought to undermine their accounts. Both suffered severe trauma that was ignored by the police. Both were racially stereotyped by the police. Both were treated like criminal suspects, not victims of crime, with no charges ever brought in relation to the racist attacks on them. Both were victims of institutional racism that permeated the police, and for present purposes, both were wrongly targeted by undercover officers. In 1999, Sir William Macpherson, the chair of the Stephen Lawrence Inquiry, made critical findings in respect of Mr. Brooks, including the following. 1. The greatest trauma suffered by Mr. Brooks was that he saw his friend murdered, dying on the pavement and dead as he was carried into the hospital. And he has had to endure that night and the whole course of the failed investigation. He was a primary victim of the racist attack. He is also a victim of all that has followed, including the conduct of the case and the treatment of himself as a witness and not as a victim. 2. To say that there were real lessons for the police to learn about how Mr. Brooks was handled at the scene and that the police did not deal with Mr. Brooks very well at all were understatements. No officer treated Mr. Brooks properly at the scene or later at the hospital. No officer at any time treated him properly as a victim. There is no evidence that any officer understood that Mr. Brooks needed close, careful, and sensitive treatment. Mr. Brooks was simply treated as a potential witness and inadequately at that. 3. We are driven to the conclusion that Mr. Brooks was stereotyped as a young black man exhibiting unpleasant hostility and agitation who could not be expected to help and whose condition and status simply did not need further examination or understanding. We believe that Mr. Brooks' color and such stereotyping played their part in the collective failure of those involved to treat him properly and according to his needs. And 4, we are satisfied that the lack of respect and sensitivity in handling him must reflect unwitting and collective racism, particularly in those who dealt with him both at the scene of the murder and at the hospital. Mr. Brooks was a victim of racist stereotyping. We do not believe that a young white man in a similar position would have been dealt with in the same way. He simply was not treated professionally and appropriately and according to his needs. In 1999, Mr. Brooks sought legal accountability for the way he had been treated by the police. He issued county court proceedings against the Metropolitan Police Commissioner for false imprisonment, misfeasance in public office, and negligence, and against 13 named officers for breaches of the Race Relations Act 1976. The Court of Appeal held in 2002 that Mr. Brooks' claims against individual officers for racial discrimination in the provision of services were permissible and should not have been struck out at first instance, even though Mr. Brooks did not make his needs as a victim of crime known to each officer who was providing him with services. This significant principle remains good law today and was untouched by the House of Lords, who in 2005 struck out Mr. Brooks's claim for negligence against the Commissioner, ruling the police settled the rest of Mr. Brooks's claim, apologizing to him for the way the police had treated him and paying him damages. Despite his mistreatment by the police, Mr. Brooks has done everything that was asked of him from day one. He assisted 3 separate police investigations. He made at least 9 witness statements during the first investigation alone and attended 3 identification parades and various drive-arounds. During the private prosecution in 1996, he gave evidence as requested, despite being medically unfit to do so. Whilst taken into a form of witness protection, he was guarded at one point, astonishingly, by a police officer who was a known associate of Clifford Norris, a notorious criminal and father of David Norris, one of those suspected at the time of having murdered Stephen Lawrence. During the subsequent murder trial of David Norris and Gary Dobson in 2011, Mr. Brooks gave evidence despite the death of his father the night before. The 2 men were convicted nearly 19 years after Stephen Lawrence's murder and sentenced to life imprisonment. Mr. Brooks has been equally committed to exposing racism and corruption in the police. He assisted the Stephen Lawrence Inquiry, the Police Complaints Authority, the Independent Police Complaints Commission, the Independent Office for Police Conduct, Operation Hearn, and the Stephen Lawrence Independent Review. Largely hidden from the limelight and always self-effacing in demeanor, Mr. Brooks continues to be dedicated to the pursuit of truth. For more than 25 years, Mr. Brooks has sought to make a positive contribution to society, notably by doing all he can to improve policing and race relations. He has supported many individuals, families, and campaigns fighting for justice and against police brutality. He has also strived to improve the support given to victims of crime. He has worked with policymakers and strategists to improve engagement and communication between the Metropolitan Police Service and diverse communities in London. He joined the Met's Operation Blunt 2 initiative to combat knife crime in London. He was an independent member of the Met's Firearm and Taser Reference Group, which scrutinized the police use of firearms and tasers in London. He led an engagement team on the Territorial Support Group and the River Team. He was a member of the Mayor's Office for Policing and Crime Stop and Search Group. He has contributed to the College of Policing Strategic Command course and delivered equality and diversity training at the College of Policing. He was a Liberal Democrat councillor in the London Borough of Lewisham from 2009 to 2014. He led on stop and search scrutiny, attending Met Gold Group meetings following critical incidents in the borough, and was instrumental in establishing a system for the online reporting of crime against the LGBT community. He spent 4 years as a lead member on the Safer Communities Board of the Local Government Association. He was awarded an OBE in 2015 for public and political service. He presented an award-winning BBC documentary in 2019 entitled Stabbed, Britain's Knife Crime Crisis. He is the chair of trustees at Juvenis, a black-led charity dedicated to empowering young people who are vulnerable to crime, exclusion from school, and exploitation. He was a member of the Windrush Cross-Government Working Group from 2020 to 2023, which supported the delivery of practical solutions to address the challenges affecting the Windrush generation and their families, and revamped the compensation scheme. He led on the implementation of the recommendations in Wendy Williams' Windrush Lessons Learned Review. And finally, he was appointed to the Youth Justice Board in 2023 for a tenure of 3 years. But despite all that public service, despite all that activism, or maybe because of it, Mr. Brooks was subjected for many years to inappropriate police harassment and covert surveillance. He is keen to acknowledge at the outset that he is acutely aware that the impact of the spying on him was nothing compared to the impact of the spying on, for example, the women who were deceived into relationships. Nevertheless, it is essential that the inquiry examines the police spying on Mr. Brooks in full, as required by its terms of reference. It is important to note that by no means all the spying on Mr. Brooks was by undercover officers in the Special Demonstration Squad. Plumstead Police Station had a racial incidents unit. Police Constable Alan Fisher, the racial incidents officer, got to know black victims of racist crime he was there to assist. In what can only be described as a breach of trust, he was deployed as a plainclothes spotter at the May 1993 anti-racist demonstration against the British National Party in Welling, presumably to identify black people he recognized in attendance. Learning this has left Mr. Brooks speechless as it may leave many others speechless too. Mr. Brooks finds it profoundly disturbing that the police were spying on him and other victims of racist violence, but not, as far as he is aware, on well-known racist criminal groups who were committing serious violent crimes. Pausing there, it appears that this fundamental failing has finally been acknowledged by the Met in its Tranche 3 Phase 1 opening. It is significant that the Metropolitan Police Service now accepts, firstly, that undercover officers indefensibly reported on individuals, family justice campaigns, and police accountability groups, including Mr. Brooks, who presented no risk of criminality or public disorder. And secondly, that instead of such reporting, the prevention and investigation of racist violence should have been properly resourced, which it clearly was not. We trust that the inquiry will give credit where credit is due. It is undoubtedly because of the perseverance of so many individuals, campaigns, and groups, including Mr. Brooks and the family of Roland Adams, that this concession has at last been made. In light of this concession, we trust that the inquiry will properly investigate the extent to which the undercover policing of racist individuals and racist criminal groups was under-resourced. Another incident of concern to Mr. Brooks involved Deputy Assistant Commissioner John Grieve of the Metropolitan Police Service. One of his initiatives, after taking charge of the Stephen Lawrence murder investigation, was to set up a series of meetings with Mr. Brooks and his solicitors. This was during the post-McPherson era, when the police was supposed to have learned lessons from the past. Before one of those meetings in May 2000, whilst he sat in the offices of Dighton Gadala solicitors, he gave himself authority to covertly record the meeting and proceeded to do so. We understand that this is unlikely to have been the only such meeting that was covertly recorded. As far as SDS spying on Mr. Brooks is concerned, some of it was highlighted by Mark Ellison, Queen's Counsel, in the Stephen Lawrence Independent Review, published in 2014. Whilst the primary focus of the Ellison Review was police corruption in the original investigation into Stephen Lawrence's murder, the Ellison Review also examined the role of undercover policing in the investigation and explored the extent, purpose, and authorization for any police spying on Mr. Brooks. In respect of undercover policing, Mr. Ellison concluded that although there were no surviving SDS records supporting the contention of Peter Francis, the former SDS officer who was deployed undercover in September 1993 and turned whistleblower in 2013, that he was tasked to gather intelligence that could be used to smear or undermine the Lawrence family campaign. It is clear the majority of SDS records from that era had been destroyed. In any event, if there had been such tasking, it would most likely have been oral rather than recorded in writing. Second, no definitive findings can be made concerning Mr. Francis's various claims, including his claim that Special Branch asked the Stephen Lawrence murder investigation team to ascertain and report back the names of individuals and groups present in the Lawrence family home in the weeks following the murder. 3. In August 1998, an SDS officer we now know was David Hagan, whilst spying on the Lawrence family, met with an ex-Special Branch officer, Detective Inspector Richard Walton, who was seconded to the Met team that was drafting the final written submissions to be made on behalf of the Commissioner to the Stephen Lawrence inquiry. This was wrong-headed, inappropriate, and highly questionable, Mr. Ellison concluded. There was no conceivable public order justification for this meeting. 4. The Met should have provided Sir William McPherson with the information regarding undercover policing that touched on the Stephen Lawrence murder investigation, but failed to do so. If the withheld information had been provided, it is likely that the Met's case at the inquiry and its reputation as a whole would have been further and severely damaged. In respect of Mr. Brooks, Mr. Ellison concluded that 1. Mr. Francis's claims that he was tasked in September 1993, soon after being deployed undercover as an SDS officer, to identify Mr. Brooks in footage of the May 1993 demonstration against the BNP in Welling. As it happens, Mr. Brooks had already been identified in the footage by another police officer. It is possible, Mr. Ellison concluded, that Mr. Brooks was identified independently by both officers. 2. The circumstances surrounding the prosecution of Mr. Brooks for offences arising from the May 1993 demonstration in Welling and the Met's handling of this prosecution remain somewhat unsatisfactory. No clear explanation has been provided as to why it was considered appropriate to charge Mr. Brooks in October 1993 when the case against others for similar alleged offending had already been dropped. 3. There was further SDS reporting on Mr. Brooks after the publication of the McPherson report, namely between 1999 and 2001. This was largely about gathering personal information about Mr. Brooks and tactical information about the progress of Mr. Brooks's civil claim against the Commissioner. Such reporting should not have taken place, and in any event should have been terminated by SDS managers once they learnt of it. It had little value in terms of legitimate public order concerns. It should never have been disseminated, as it was, to other parts of the Met, such as the unit dealing with Mr. Brooks as a victim and a vulnerable witness. 3. Deputy Assistant Commissioner Greaves's covert recording of a meeting in May 2000 with Mr. Brooks and his solicitors was unnecessary, unjustified, and no doubt compounded Mr. Brooks's concerns about the activities of the Met as a whole. Ultimately, the Ellison Review raised many questions about the police treatment of Mr. Brooks generally and the SDS spying on Mr. Brooks specifically. For example, why was the SDS interested in Mr. Brooks in the months following the racist murder of Stephen Lawrence in the first place? Surely the focus of any undercover policing in 1993 should have been on those suspected of having murdered Stephen Lawrence, not on the surviving victim of the attack. Why was Mr. Francis asked to identify Mr. Brooks in footage of the May 1993 demonstration against the BNP in Welling? Why was Mr. Brooks charged with offences arising from that demonstration when the charges against others for similar offences had already been dropped? What possible justification could there have been for the SDS spying on Mr. Brooks between 1999 and 2001? What possible justification could there have been for Deputy Assistant Commissioner Grieve covertly recording a meeting with Mr. Brooks and his solicitors? All questions that clearly arise, we suggest, from the Ellison Review. Turning then to the undercover policing inquiry, the SDS intelligence reports and other material recently disclosed to Mr. Brooks provide yet further evidence of police intrusion into his life and breaches of trust. Peter Francis, HN 43, and David Hagan, HN 81, were two SD officers who we know reported on Mr. Brooks. According to Peter Francis, 1. There was racist banter amongst SDS officers as a group and much more overt racism from certain members of management. A detective chief inspector in the SDS, HN 86, referred to black justice campaigners as monkeys, and Detective Chief Superintendent Robert Potter, whose police career was later ended when he was arrested for racist behavior in a public place, indulged in casual racism using the N-word regularly. 2. The special branch attitude towards the Lawrence family was 100% racist. They were viewed as being unable to think for themselves or run their campaign themselves and must therefore have been led by others. 3. HN 86 and other police officers often spoke nastily and disparagingly about Mr. Brooks with a racist spin on a lot of it. People deliberately mispronounced his name with the intention of making him sound like he was thick. HN 86 once said that if only it was Mr. Brooks who had been stabbed, nobody would have been interested in a kid who was living in a hostel as opposed to a kid from a good family like the Lawrences. Pausing there, sir, HN 86 was not the only police officer to make such a disgusting comment about Mr. Brooks. The inquiry has disclosed a document to Mr. Brooks which reveals that a Detective Constable David Dougal told two Operation Hearn investigating officers on the 19th of February 2014 that, quote, the wrong person got stabbed, end quote. Returning to Peter Francis, he had private meetings with HN 86, which included discussions about identifying people on a list provided by the Lawrence family liaison officers and viewing footage to identify Mr. Brooks at the May 1993 demonstration. 5. He was tasked by HN86 to report anything that he could find about the Lawrence family, that campaign, Mr. Brooks and others, that had the potential to smear and discredit or could be used by the police to alter public perception. 6. He was also tasked at various points during his deployment to report on black justice campaigns, including the Roland Adams family campaign. 7. In 1997, HN86 and Roger Pierce told him there would be battles in the street if his spying on the Lawrence family campaign and other black justice campaigns were disclosed to the Stephen Lawrence inquiry and the public found out what he'd been doing. As far as David Hagan is concerned, the chair has recently ruled that he is excused from attending the Tranche 3 hearings on the basis that giving oral evidence would apparently risk causing a severe impairment of his health. This is a major setback and a slap in the face for all those non-state core participants on whom Mr. Hagan spied and reported. They have been waiting for years patiently to hear how Mr. Hagan seeks to justify what he did. Mr. Brooks is furious. There's no other way to put it. Mr. Hagan will no longer be required to explain any of the following. Why did he spy and report on Mr. Brooks between 1998 and 2001? Was he ever tasked by a senior officer to spy and report on Mr. Brooks, and if so, by whom? Why did he report on personal matters concerning Mr. Brooks that had nothing to do with public order? Why did he report on Mr. Brooks' civil claim against the commissioner? Why did he patronizingly and wrongly suggest in an intelligence report that Mr. Brooks was incapable of making his own decisions and was being manipulated by Alex Owolade from the Movement for Justice? To what extent was his reporting based on fabrication and or exaggeration and or gossip? Was there any racist banter amongst SDS officers? Was there more overt racism from senior SDS managers? Did he ever witness HN86 do or say anything that was racist? None of that now is capable of further exploration, unfortunately. Turning then to the issue of Mr. Brooks giving evidence to the inquiry. Mr. Brooks argued for and welcomed this inquiry. He willingly took part in early discussions with the then Home Secretary and the inquiry team in the build-up to the first hearings in 2020. Since then, he has become increasingly despondent. The process has dashed his expectation and dampened his belief that the inquiry will ever meaningfully meet its terms of reference and treat those who have been wrongly spied on with the respect and humanity they deserve, rather than as inconvenient witnesses. There appears to be little understanding of the painful experiences that so many non-state core participants have suffered and how the spying and intrusion have affected their daily lives. In stark contrast, there is far too much deference to the police and SDS officers. Mr. Brooks also wishes to reiterate what other non-state core participants have already highlighted, namely that it is outrageous that some SDF officers who apparently spied on the far right are giving evidence in closed hearings from which the non-state core participants, their lawyers, and the general public are excluded. This is particularly galling given the fact that some information about their infiltration of far-right groups is already in the public domain. What possible national security or privacy concerns could justify not hearing evidence in open hearings about events that took place over 25 years ago? Additionally, when is the inquiry going to explore the nature and extent, if any, of undercover policing of racist criminal groups? Mr. Brooks understands that a key purpose of the non-state core participants, let me rephrase that. Mr. Brooks understood that a key purpose of the non-state core participants participating in the inquiry was that they would at long last be provided with answers to questions that have been unanswered for years. However, this is simply not happening for the vast majority of non-state core participants. On the contrary, for some, the inquiry is merely adding to the trauma they have already suffered. Additionally, Mr. Brooks is still awaiting substantial disclosure from the inquiry about various important matters, some of which he has been told will not be available until early 2026. This additional delay in disclosing all relevant material is understandably a matter of considerable concern for Mr. Brooks. He is incensed that the inquiry has asked him and other non-state court participants to provide witness statements and give oral evidence before seeing all the undercover reporting about them and before hearing the oral evidence of the police officers who spied on them. He believes this is fundamentally unjust and disrespectful. It stacks the scales against the non-state court participants and undermines their ability to give their best evidence, thereby thwarting the inquiry's ability to meaningfully fulfill its terms of reference. In what other legal forum would the victims of abuse of power by the state be expected to give evidence before they've had full disclosure of the precise nature and extent of that abuse? In the opening statement made on his behalf in November 2020, prior to the Tranche 1 hearings, Mr. Brooks's position was made crystal clear, and I quote, "As far as the inquiry itself is concerned, I can be brief about Mr. Brooks's position. It is simple. When Mr. Brooks is provided with full disclosure about the undercover policing against him, he will address it, but not until then. He is the first to accept that he has, as a result of a long struggle, received some information about the spying on him from the Metropolitan Police and others. He has more than most, but he's received nothing from the inquiry, and there's a lot more to come. What Mr. Brooks is not prepared to do is be treated like a suspect all over again, giving yet another account, answering the inquiry's questions in advance, as if the burden is on him to establish that there was no good reason for the police spying on him," end quote. That remains Mr. Brooks' position today. Having said that, he has provided the inquiry with a first witness statement. He remains willing to give oral evidence and assist the inquiry. However, he is not prepared to do so until he has been given full disclosure of all the undercover reporting about him and has had sufficient time to digest the material and give instructions to his legal team. This position is nothing other than reasonable. We trust that the inquiry will provide Mr. Brooks with the outstanding disclosure as soon as possible, give him sufficient time to provide an updated witness statement, and ensure that he can give oral evidence during the Tranche 3 hearings in 2026. Anything else would be grossly unfair to Mr. Brooks. It would also frustrate the inquiry's task of getting to the truth about undercover policing. Sir, in conclusion, given the public order threat assessment in the SDS annual report of 1993-1994, it is perhaps unsurprising that the police, including the undercover police, got it so hopelessly wrong when investigating Stephen Lawrence's murder. The report makes the following assertions. 1. An increasingly violent campaign against racial aggression commenced following Stephen Lawrence's murder. 2. The far right pose a shrinking public order threat. 3. Public disorder with an anti-racist theme has been the major feature of the past year. 4. The argument that the presence of the British National Party bookshop in Welling inspires racists to commit acts of violence and directly adds to the increase in the number of racist attacks, quote, is by no means indisputable, end quote. In other words, what this report was saying is that it was the victims of racist violence and the anti-racist who posed the greater public order threat than the perpetrators of racist violence and the far right. It is precisely this perverse analysis that led to Mr. Brooks, the surviving victim of a racist murder, being mistreated by the police and spied on by the SDS, whilst Stephen Lawrence's murders walked free. It was not until 2010 that the police finally charged 2 of those responsible with murder. If the police, including the undercover police, had effectively policed the far right and racist criminal groups, instead of persecuting and criminalizing the victims of racist violence, then perhaps some of the racist attacks, including some of the racist murders that plagued our communities during the 1980s and 1990s, could have been prevented. It is noteworthy in this regard that Sir William Macpherson recognized the importance of the police having good intelligence on racists and racist criminal groups. I quote from the report, "The extreme nature of their racism and violent tendencies suggest to us that they should have been spotted for what they were, if good intelligence and information had singled them out earlier and detected their evil presence on the estate. Then perhaps they would have been even more obvious targets for early arrest." Finally, sir, the inquiry will wish to attach significant weight to the fact that Mr. Brooks and other black non-state core participants who have provided the inquiry with witness statements, including Richard Adams, John Burke Munaville, Suresh Grover, Lee Lawrence, Neville Lawrence, Asad Rahman, Bernard Renwick, Myrna Simpson, and Mark Wadsworth all describe such similar experiences of racist policing. What is abundantly clear from the thrust of all their witness statements is that so many black individuals, families, and justice campaigns were spied on by the police precisely because they were challenging the injustice of racist policing, not because they posed any public order threat. In the circumstances, Mr. Brooks asked the inquiry to unreservedly and unequivocally condemn such police spying and reporting as wholly unjustifiable. Thank you.
Thank you. There's only one thing that I should say about Mr. Brooks's giving evidence, that because he is unable or unwilling to take the slot that was allotted to him in this part of the Tranche 3 hearings, it may not be possible to hear his oral evidence at a later stage. It depends upon something unexpectedly becoming available.
Well, I hope the inquiry will use its best endeavors to ensure that he is capable of giving evidence in 2026. I note, for example, we often don't sit on Fridays. There are plenty of days here and there where I hope his evidence can be slotted in, because his evidence is of critical importance to your eventual findings when you prepare your report, sir.
Thank you. Now, I think our transcribers need at least 10 minutes, do they not? It is now 7 minutes to, and I think we ought to begin at 5 past. Is that long enough for you? Right, we'll resume at 5 past. Mr. Odogwu.
Good afternoon.
I'm sorry you've been slightly delayed.
No problem, sir. I represent Dr. Neville Lawrence, OBE, together with Adam Straw KC and Hodge Jones and Allen solicitors. This opening statement is made on behalf of Dr. Neville Lawrence, OBE, and complements our written opening filed with the inquiry team. Set across the Tranche 3 period is a defining event in modern British life, the racist murder of Stephen Lawrence on the 22nd of April, 1993. Dr. Neville and Baroness Doreen Lawrence led a peaceful campaign that asked only for justice for their son and competence from the authorities. While the Lawrences sought justice, state power turned on the family. From the earliest days after Stephen's murder, the Metropolitan Police, through Special Branches SDS, began collecting and circulating intimate information about the Lawrences and those assisting them. That activity continued for years and reached into the McPherson inquiry itself. The Commissioner now accepts that reporting on Dr. Lawrence and his family was wholly indefensible. In this opening, I start with highlighting some of that surveillance before turning to the question of race discrimination. Turning first to the surveillance of the Lawrence family, there are 5 points we wish to highlight in opening. First, surveillance started almost at once. On the day after the murder, family liaison officers, otherwise known as FLOs, visited the home that evening. What should have been a bridge between a bereaved family and a murder investigation became an exercise in control and extraction. Visitors to the Lawrences' home were asked to identify themselves. Names were taken and recorded according to the FLOs themselves. What followed, if the evidence is accepted, is stark. Those names were onward routed into special branch channels. Peter Francis says HN86 handed him a list which was said to be from the FLOs. In his words, his task was to, quote, ascertain the political persuasion of the people on the list. The more militant the people on the list, the higher risk the campaign would create a public order issue. Chair, it was submitted yesterday on behalf of the designated lawyers that one of the reasons Peter Francis' allegation is not credible was the absence of contemporaneous documentation. However, little weight can be attached to the absence of records for the reasons already set out in the Alison review. Communication was frequently solely oral, and many documents have been destroyed or lost. One of the features of this intrusion, which is especially significant, is the timing. This happened within days of the killing, when the family should have been treated with the utmost sensitivity. Dr. Lawrence tells this inquiry in his statement that what happened in his home was deeply troubling. He says, quote, the implication that we were somehow the ones to watch was as perverse as it was offensive. It was as though our grief was treated as a threat and our home as a site of suspicion, something I will never accept or forgive. Second, Peter Francis' allegation that he was tasked to smear the Lawrences. Francis says he was, quote, tasked by HN86 to report anything I could find out about the Lawrence family and or the campaign that could fundamentally alter the perception of the public about the campaign. He said, the gathering of intelligence on the Stephen Lawrence campaign was SDS's #1 priority. In Tranche 2, we heard from HN78. His account does not contradict Francis. On his own account, he did not know what personal information about the Lawrence was reported or how it was used. He accepted that he provided, quote, quite a lot of reporting about the Lawrence campaign and that it, quote, might well have contained personal information, and that material capable of smearing the Lawrences was reported back. Thirdly, the wider evidence of unjustified surveillance on the Lawrences. By their own admission, both HN78 and Francis confirm a deliberate intrusion by the SDS into the Lawrences' private lives. Personal material was gathered and circulated, knowing it could be used against them. In a landscape already scarred by missing and destroyed documents, those frank admissions alone are the chilling touchstones of this inquiry. Within weeks of the Macpherson hearings, intelligence reports notes that Doreen and Neville have, quote, in reality, separated. Another note repeats this, saying, quote, this is not public knowledge. Those are intimate facts, logged and circulated as if operational leads. They say nothing about imminent disorder, subversion, or crime. They do, however, say something plain about the priorities of the SDS. The documents also stray into subjective commentary and gossip against Dr. Lawrence, his political views, his attendance at justice campaign groups, and his public speaking. By December 2000, the reporting includes legally privileged material about the Lawrences' civil claim, including a supposed settlement figure. Two special branch reports carry financial and political gossip. One asserts a donation from BT, another suggests Dr. Lawrence was running for London mayor, and a donation from the National Lottery. Both are completely false, and in any event, irrelevant to crime or disorder. The inquiry should establish why these matters were recorded and what they were used for. Fourth, I turn to the infiltration of HN81 within Stephen Lawrence's campaign during the Macpherson inquiry. It is truly abhorrent and shocking that at the very moment the Lawrence family stood before the inquiry into MPS racism and failings, the MPS embedded an undercover officer within the campaign space around them, extracted tactical information about the family and its decisions, and channeled that intelligence into the MPS legal team's response machinery. The Ellison report captured the reality, referring to HN81 as, quote, a MPS spy in the Lawrence family camp. It was said yesterday by the designated lawyers that HN81 infiltrated MFJ, not the Lawrence family, so the label spy in the Lawrence camp is unfair. However, the evidence is clear that private and potentially privileged information about the Lawrences was obtained by HN81 during the inquiry, whatever route he took to obtain it. It was used to furnish what was invaluable assistance to the MPS legal team at the time for the specific purpose of responding to the Macpherson inquiry. The intelligence gathered by HN81 during the Macpherson inquiry was put to use immediately. Detective Inspector Bob Lambert arranged a meeting in August 1998 between acting DI Richard Walton and HN81. Walton, an ex-special branch officer himself, was then seconded to the MPS legal team defending the force before Macpherson. The Lambert file of note of the meeting is incredibly damning. A series of quotes are worth mention in this opening. Quote, it was a fascinating and valuable exchange of information concerning an issue which, according to RW, continues to dominate the Commissioner's agenda on a daily basis. The same note praises HN81's, quote, invaluable reporting on the subject in recent months and records in-depth discussion which would be of great value as he continued to prepare a draft submission to the inquiry on behalf of the Commissioner. The report adds the wider context stating, quote, great sensitivity around the Lawrence issue with both the Home Secretary and the Prime Minister extremely concerned that the Metropolitan Police could end up with its credibility in the eyes of London's black community completely undermined. Various other notes set out in our written opening demonstrate that the information HN81 obtained about the Lawrences during the inquiry was considered to be of great value and informed the MPS's position to the inquiry. The flow of information was not limited to a single meeting. Contemporaneous minutes record that, quote, DI Bolton of CO24 receives ad hoc off-the-record briefings from SDS with instructions that, quote, knowledge of the operation goes no further and that he should receive nothing on paper. and that a route had been set up to send material. It appears that this manifest abuse of covert policing occurred at the request of senior officers and with the knowledge of the Commissioner. HN81 confirms his product was provided to the Commissioner, Sir Paul Condon, from whom he received congratulations for excellent reporting. Another SDS officer, 1072, states that the tasking in relation to the Macpherson inquiry would have come directly from Sir John Stevens, the subsequent commissioner, who gave the go-ahead. Bob Lambert, HN10's representations to the Stephen Lawrence's review include confirmation that the meeting was arranged, quote, at the request of senior management, and he understood that the purpose of the meeting was so that Richard Walton could fully brief the commissioner. It is telling, Chair, that HN81 later received a commander's commendation for his work. Dr. Lawrence is deeply disappointed that HN81 has been excused from giving evidence in person. Much of his sentiments has already been echoed in today's openings by other CPs. We recognise the Chair's consideration of medical and risk materials, but the effect is that a key officer who spied on the family is not seen or tested in public after all these years. That compounds the harm to Dr. Lawrence and his family, and we reserve the right to invite the inquiry to treat HN1's evidence with particular caution and to reflect that in its conclusions. Fifth, and finally, in relation to surveillance of the Lawrences, the question of whether the undercover policing of the Lawrences was justified. Put simply, there was no justification. The Commissioner now accepts that reporting on Dr. Lawrence was wholly indefensible and that this would have, quote, rightly prompted public outrage if it had become known at the time. We invite you, Chair, to make findings to at least that effect on the following basis. First, as CTI correctly stated in opening yesterday, the Lawrence family had done nothing themselves to justify undercover policing. They were not engaged in violence, crime, disorder, or subversion. The police materials themselves proceed on that footing. Second, the reporting cannot be justified as necessary to monitor other groups. The contemporaneous record shows that the family did not support any of those groups. Examples are littered throughout the intelligence reports and that of our written opening. Third, the nature of what was collected. The intelligence was intimate, irrelevant, and sometimes privileged. None of that serves a public order aim. Fourth, the timing. As mentioned, within days of the murder, FLOs were logging visitors and names were checked for political persuasion. That predated any realistic basis to suspect disorder and rested on groundless suspicion. Timing is relevant to the fifth reason, which is proportionality. The undercover policing of the Lawrences occurred at the times of the utmost sensitivity, while resources should have been focused on finding Stephen's killers and during Macpherson. An intrusion in such highly sensitive periods require a compelling case, and there is none. The second and final topic I addressed, Chair, in this opening is the question of race discrimination. Chair, the question that sits behind all of this is why these powers were used in this way. We're grateful that counsel to the inquiry yesterday underlined the importance of a full examination of race in these hearings, and we welcome the inquiry's commitment to make clear findings on it. This inquiry should publicly investigate and find whether the undercover policing of the Lawrences and others like them was race discrimination or otherwise racist. That goes to the inquiry's core function under Section 1 of the 2005 Act to address matters of public concern. Public concern about race discrimination by the MPS is long-standing, identified by Macpherson and undiminished to this day. It affects confidence, cooperation, and public safety. Only a thorough examination will meet that concern. 3 principles guide that analysis. 1, direct discrimination is less favourable treatment because of race. The question is whether the Lawrences were treated worse than comparable white families. 2, discrimination is often unconscious. Overt proof is rare and inferences from surrounding facts are critical. 3, tribunals may draw common sense inferences, including from patterns and similar fact evidence. Race need not be the sole motive. If it had a significant influence, discrimination is made out. On the disclosed material, there is weighty evidence that the undercover policing here was racially discriminatory. I summarize it in 5 short areas. 1, disproportionate surveillance on Black people. The materials show a striking disproportionality. Black bereaved families, Black-led justice campaigns, and anti-racist organizations were treated as objects of suspicion, routinely infiltrated and written about in intimate detail, while violent white racist groups received markedly less intrusive attention. Trevor Morris accepts he provided, quote, quite a lot of reporting on the activities of the SWP around the Lawrence campaign. SDS undercover officers also reported on campaigns for Cherry Gross, Blair Peach, Brian Douglas, Ricky Will, Roland Adams, and others, and across civic organizations such as New Monitoring Project, Youth Against Racism in Europe, the Anti-Nazi League, and Anti-Fascist Action. These were peaceful attempts at accountability, yet were treated as matters of subversive interest. By contrast, sustained SDS penetration of violent racist organization is thin. This was not for lack of targets. The period saw NF, BNP, Combat 18, British Movement, National Socialist Movement, Blood and Honour, and associated violence up to and including David Copeland's 1999 nail bombings. Yet the evidence shows very limited undercover work against these groups, aside isolated short deployments and some security service files. Nothing comparable to the systemic attention given to the Black family justice and anti-racist campaigns that we've already heard today in opening. If the inquiry concludes that there was a disparity, the next question it must ask is why. The suggested explanations don't hold. The notion that the far right was too violent to infiltrate is untenable. Undercover policing has long operated in violent environments, and the size and spread of groups like the BNP offered multiple lower risk entry points. If public order was the touchstone, the police purpose for infiltrating the racist groups was stronger, not weaker, than for surveilling bereaved families and community groups. 2, overt evidence of racism. A further indicator that the undercover policing of the Lawrences and similar groups was discriminatory is the overt racism evidenced in the chain of command. In 1993, it is alleged HN86 referred to the Lawrences with the phrase, "the monkeys were being organized." Robert Potter was said to routinely use the N-word, a complaint that was made about him for racist behavior in a public place led to the end of his police activities. Peter Francis describes Potter as having, quote, a hatred of Black people. We do not say that every SDS manager shared those views. The legal point is simpler. Direct evidence of racist language and attitudes within relevant supervisory lines is probative of discriminatory decision-making, especially where, as the case law recognizes, discrimination is often unconscious and proved by inference from surrounding facts. That some of this language, when unchallenged at the time, strengthens the inference that race had a significant influence on targeting, tasking, and reporting in this case. Thirdly, racial profiling and categorization. Across the disclosure, people are routinely labeled by race rather than risk. Reports speak of, quote, other colored groups, a meeting of, quote, chaired by an unidentified male Negro, about half were colored. Head counts like, quote, some 60 people were present, half of them Black, a child described as half caste, and even a specific note of a, quote, Black heterosexual member of MFJ, as if that in of itself were operationally significant. We also learned Special Branch maintained a, quote, black and browns desk. The habit of counting black attendees or noting ethnicity as a standalone feature evidences race-conscious surveillance and supports the inference that race was a reason for the extent of the undercover policing. 4. Wider evidence of race discrimination. The surveillance on the Lawrences did not occur in isolation. Bereaved families, anti-racist campaigners, and police monitoring groups, some of which you've already heard today, Chair, were treated as intelligence targets as set out in our written opening. The Chair also, Chair, you have also the benefit of extensive submissions from the other core participants on those matters. That similar fact record is probative of improper purposes here and is relevant to the inferences in this case. There is substantial wider evidence of race discrimination within the MPS. McPherson found institutional racism in the MPS in its treatment of the Lawrences. More recently, the KC review concluded that institutional racism persists across a range of MPS functions. Taken together, these reports show a problem that is systemic, rooted in culture and systems. Fifth and finally, the lack of race discrimination training. The system's safeguards against race discriminations were threadbare at best and calls for an examination in Tranche 3. HN81 says he received just 1 day of race equality training. Francis recalls racial awareness training at Hendon, but none thereafter. The combination of scant and perfunctory race training may explain how discriminatory practices could persist and is capable of supporting an inference of discrimination in of itself. Taken together, Chair, these factors provide cogent prima facie evidence that the undercover policing of the Lawrences and other Black justice or anti-racist groups was racially discriminatory. We invite the inquiry to carefully examine these issues. At the end of this tranche, if the evidence does not demonstrate an even-handed approach, and there is no good reason for the disproportionality, Dr. Lawrence will invite you to come to a clear conclusion of race discrimination. Chair, in conclusion, we ask the inquiry to examine closely why covert power was turned on a bereaved Black family, to find the surveillance of Dr. Lawrence was wholly indefensible and unjustified, as it is now accepted by the Commissioner, to examine how it was used and whether race played a significant part. We welcome the Council to the inquiry's commitment to test those issues fully. Thank you, sir.
Thank you very much, and thank you for completing your opening submissions in slightly under the time that you were allotted. It's enabled us to catch up with ourselves. Very grateful to you. Thank you.
Thank you.
Dave Morris. Good afternoon, Mr. Morrison. Thank you for waiting patiently, and you're at the back of the queue, I'm afraid.
No problem. Thank you very much. Can you hear me okay?
Yes, we can.
Okay. So I am a core participant and make this short oral opening statement as one of the McLibel case defendants. The other defendant is fellow core participant Helen Steele. She is currently preparing her own detailed witness statement on wider issues, including the shocking extent of the SDS's impact on her life. But firstly, I'd like to say, having listened to the harrowing statements made today, let me extend my solidarity to the other non-state core participants. We have all been heavily impacted by what the Met Police yesterday admitted was a dysfunctional undercover unit, the human toll of which they now accept was severe and wide-ranging. Your own 2023 interim report as the inquiry chair had already concluded that the SDS should have been brought to a rapid end in the early 1970s. If it had been, its industrial-scale breaches of people's rights and lives and the undermining of movements for positive change would not have taken place. The McDonald's Corporation versus Steele and Morris court case resulted from a London Greenpeace campaign against the burger giant in the mid-1980s. We were sued for libel in 1990. It became the longest trial in English history. We had been denied legal aid, so had to defend ourselves, supported for free behind the scenes by a barrister, Keir Starmer. It ended with a victory in the European Court of Human Rights in 2005. The proceedings involved a prolonged and colossal effort by the three of us and a great deal of stress. The inquiry has begun to shine a light on a dark and highly significant secret: the involvement of the SDS and the two-way collusion between the Metropolitan Police and McDonald's in the 1980s and 1990s. But there remain vital questions which now need answering by witnesses, admissions and disclosure during Tranche 3, including how long did the collusion go on for, who knew about it, and who authorised it. Inquiry documentation has already revealed a great deal of evidence, which I have outlined in detail in my written statement published today, I believe. So what are some of the things that we know already? HN10, Bob Lambert, helped to research and write the What's Wrong with McDonald's fact sheet, which became the subject of the libel action. He and another infiltrator, HN5 John Dines, both enthusiastically took part in the anti-McDonald's campaign and distribution of the fact sheet. Dines engineered a long-term intimate relationship with London Greenpeace participant Helen Steele, characterised by counsel to this inquiry a year ago as, quote, cold, calculating, emotional and sexual exploitation. McDonald's themselves hired 7 spies to infiltrate London Greenpeace for an 18-month period to identify who was active in the campaigning. Dines became aware of these individuals and who they were. The security services were made aware of McDonald's spies and asked for a more detailed report from the SDS. McDonald's head of security, Sid Nicholson, and his deputy, Terry Carroll, both former Met Police chief superintendents in Brixton Police Station in the early 1980s before being employed by McDonald's, were aware of Dines and the SDS operation. It should be noted that Bob Lambert had been a special branch officer with responsibility for the Brixton area also in the early 1980s. Sid Nicholson testified during the McLibel trial that McDonald's security were, quote, all ex-police, and he could get information on protesters from former contacts. HN67 Alan Bond told Dines that he had known about the McDonald's spying operation from the outset, and that McDonald's knew who Dines was. Dines was arrested at the Trafalgar Square poll tax disturbances. Commander Gunn, who I'll talk about later, pulled Dines' charges and the paperwork was destroyed. HN67 Bond was temporarily transferred to a special branch unit investigating the Trafalgar Square events. An officer of that unit had meetings with one of the McDonald's spies, and they shared confidential information about participants in London Greenpeace. We later successfully sued the Met over this, but they concealed the much greater collusion with McDonald's through the SDS. Dines' witness statement explains that he was, quote, omitted from the writ served by McDonald's originally on 5 of those active in the campaign, and that this action, obviously by senior officers in collusion with McDonald's, threatened to compromise his deployment It seemed to be a risk they were willing to take. Dines reported in advance the exact date McDonald's had planned to serve the writs. Once the writs had been served, McDonald's security manager Terry Carroll said he was going to contact Special Branch for an assessment. Dines reported, presumably by exploiting his relationship with Helen Steele, on an early closed meeting of the 5 original defendants in which we discussed legal strategy, and also on later legal strategy meetings. Dines has admitted, "It is accurate to say I was by the side of Helen Steele and Dave Morris in 1991 and relaying the legal advice, i.e. from Keir Starmer, back to my bosses in the SDS." Bob Lambert was SDS manager during the McLibel trial. Sid Nicholson was overseeing the litigation for McDonald's. Establishing the facts on who had been involved in helping create and publish the anti-McDonald's fact sheet was a fundamental issue during the McLibel proceedings at every level up to and including the European Court. The courts were misled at every stage. Lambert was in charge of a major operation to try to prevent Helen Steele tracking down her ex-partner Dines, who had disappeared without trace, faking a mental breakdown. He reported that if she found him and discovered the truth, then they, that is Helen, myself and Keir, would give serious consideration to subpoenaing Dines and or the Commissioner to give evidence at the McDonald's libel case. In other words, the SDS and MPS were knowingly sabotaging the opportunity to call a key witness during a major trial. Would this have led to the collapse of the McLibel trial and the closure of the SDS? As can be seen, there was extensive collusion, breaches of legal privilege, misfeasance in public office, interference with legal process, and maybe most significantly, lying to and misleading courts by the failure to disclose vital evidence throughout the McLibel hearings right up to the European level. When asked about some of this in Tranche 2, SDS managers testified that such collusion would have to be authorised at a higher level than the SDS, probably commander level. I understand that Commander Gunn who was the commander at the time, produced a position paper regarding the special branch having established excellent links with commercial and industrial organisations, including through delivering presentations and briefings and offering what he termed, quote, a consultancy service. Commander Gunn is giving evidence next Monday, and Deputy Assistant Commissioner Phelan at some point. They're both so they'll both be giving evidence during this phase. They were the higher levels at the key early stages of the McLibel story, so need to be robustly questioned. Who knew about these matters? How long did it go on for? How was the collusion conducted? How high up was the authorization given? Who liaised with McDonald's? What was the role of Bob Lambert? What was the role of the security services? Why was it allowed to happen? I also ask, who now is going to take responsibility and apologise unreservedly for this scandal? I acknowledge and welcome that a number of apologies have already been made by the Metropolitan Police for the serious wrongdoing by the SDS. Like many core participants, I am currently awaiting a full witness statement from the Home Office and for an apology from the Home Secretary for successive governments authorising and signing off these secret political policing deployments. Thank you.
Thank you very much indeed. We will resume tomorrow at 10 when the final opening submissions on behalf of core participants will be made. I anticipate we will finish by mid or early late afternoon tomorrow.